For some time in this country, we've been talking about wage theft, about where people are not given the wages they're legally entitled to. The case with respect to what's been decided with WorkPac, what's been decided for Mr Rosato, instead of dealing with wage theft, it deals with security theft. It deals with where people have had the job security that they were legally entitled to taken from them. I've got to say, I'm astonished by the government's reaction to this the whole way through, where they are talking about extraordinary sums of money that they believe will now need to be paid as a result. That would only be the case if there has been widespread breaking of the law by Australian employers. Now, I certainly hope that's not the case. But I have to say, if employers much more broadly than WorkPac have been acting in breach of the law, if they've been refusing to give employees the security that they were legally entitled to, then the last thing that Parliament should be doing is acting as a protection racket to cover for people who've broken the law. If job security that people are entitled to has not been given to them, then the response from the Australian Parliament, and I've got to say from the Australian Government, should be to make sure that the law is upheld. A whole lot of people, particularly casuals, have found themselves with nowhere to go during COVID-19, have found themselves not entitled to a whole lot of what is offered to people in permanent work. Every Australian right now should be on the side of job security. And this decision says that when a business has not delivered on job security, then the law should step in. We shouldn't be changing the law to let businesses that have broken it off the hook.
Well, the Australian Industry Group says that this ruling is evidence of the fact that the law doesn't define what a casual worker is, and that has led to this interpretation by judges. And the government's saying that it's going to look at regulating or legislating to remedy that. What's wrong with that?
I've got to say, the Australian Industry Group would do well to read the decision. The decision says if you have a firm advance commitment, if you have regular, reliable hours, if that's what's expected from the employee, then you're not talking about a casual. And the decision is really specific on that. Yeah, we're talking about someone here who was, for all the talk of casual loading, was being paid less than the permanent workers working beside him because he was employed through a labour hire company. So the argument that somehow they were paying more, no, they weren't. He was earning less than the workers beside him. But because the labour hire company simply wanted to define him as a casual, they say that should be enough. What the court said is no. If you're on regular, reliable hours, if you've made a firm advance commitment, then you are not a casual. And if you're not a casual, then you should get the benefits of job security, which means if you're sick, you get sick leave. During the year, you accumulate annual leave. And when you go to your bank and your bank says, are you a permanent or are you a casual, you get to say, I'm a permanent, because we all know how much more difficult it is for someone who's defined as a casual to ever be able to get a loan. The arguments from the Australian Industry Group have astonished me. It's the first time I can remember seeing a representative group of business argue that they think a large number of their members have been breaking the law. Now, if that's their argument, then they really want to come up with a better one, because if the Australian Industry Group is telling us that a very large number of employers have been in breach of the law, then I really think it's their job to say to their members, you're meant to keep the law.